Justice Gorsuch. Justice Kavanaugh.
Just pick up on the word censorship because I think it's being used in lots of different ways. So when the government censors, when the government excludes speech from the public square, that is obviously a violation of the First Amendment. When a private individual or private entity makes decisions about what to include and what to exclude, that's protected, generally, editorial discretion, even though you could view the private entity's decision to exclude something as, quote, private censorship.
Absolutely. That was the whole thrust of this Court's decision in Halleck. And I suppose the Hurley case might have been a completely different case if that was an official City of Boston parade and the City of Boston decided to exclude the group. The whole reason that case came down the way it did unanimously is because it was a private organization exercising its First Amendment right to say we don't want glib in our parade.
How does 303 fit into that?
Well, I think 303 is just further evidence that, obviously I think 303, where 303 is most relevant, is that, Colorado in that case tried to rely on fair, much the way my friends here rely on fair, and this Court made clear in 303 creative, no, it doesn't work that way. This is expressive activity. And so, and the fact that my friend's best case is fair, I think just shows how radical this statute is, because this targets expressive activity in its core. If the Solomon Amendment said to the law schools, you have to give the military equal time in the classroom, I think the case would have been 9-0 the other way. And that's essentially what Florida's trying to do here.
And then on the procedural posture, I think this is important to try to understand what's exactly before us. And you've gotten questions on this, but I want to nail it down for my benefit, which is you said that they came in and opposed a PI solely on the ground that what was involved here was not expressive activity or speech, but instead conduct. Is that accurate?
That's accurate. It came up in the context of how much discovery we were going to have before we had the preliminary injunction hearing. And in that context, the state says, look, we're going to sort of, kind of rest on this kind of threshold question, as my friend said, and that will limit discovery on both sides. And then in the 11th Circuit, it was even more clear, because in the 11th Circuit, the position of the state of Florida was like, we're not going to really engage on intermediate scrutiny at all. We're putting all our eggs in the expressive activity.
So if we think that the statute does target expressive activity in some respects, and we affirm in this case, what is left, to Justice Gorsuch's question, what's left to happen? That just means it can't go in place for the next year or two until a final judgment. What will happen in the litigation?
So there'll be litigation on the merits. I don't even think we're past the point where we could amend. So if this Court tells us we sure better have an as-applied challenge in there, I suppose we could do that. But the point is the litigation will go on. There will be discovery, unless Florida decides at that point that the writing's on the wall and it tries to pass a more narrow statute. But otherwise, there would be discovery. There would be, essentially the whole 9 yards. But in the interim, I just can't emphasize enough, particularly that $100,000 civil penalty provision.
All that's before us then is what should happen in the interim before final judgment, and it comes back to us potentially a year or two from now. Should it be in effect or not be in effect until it comes back to us?
Yeah, if
Correct?
It comes back to you, yes.
If it came back to us, or it goes to the Court of Appeals. And what will happen? You've alluded to it, but what will happen in that year, do you think? Because I don't think we've heard much about exactly what you're concerned about. In other words, you're very concerned about this, that's obvious, but what are the specifics of that?
Well, honestly, if this statute goes into effect, we'd sort of have to fundamentally change our business models. And I think each company is going to make their own judgment about how they'd come into compliance. I think, part of the irony here is that as to one of, they say this is going to promote speech, but they allow us to discriminate on the basis of content as long as we do it consistently. So, what we might do in the interim, at least some of these companies might do, is, just like, well, let's do only puppy dogs, at least in Florida, until we can get this straightened out, because that's the one way that, because, these same companies are getting hammered by people that say we're not doing enough to keep material that's harmful to children off of these sites, and yet these laws make it impossible for us to keep material that's harmful to children off of our sites unless we take so much material off of our sites that nobody can say that we're not being inconsistent or not discriminating. In Texas, it's viewpoint discrimination.
Could you just say a word about the word consistency, what you think that entails?
I have no idea, and one of the other arguments we have in this case, it's just not part of the preliminary injunction you have before us, is a vagueness challenge. And I think when you're targeting editorial discretion, to put a consistency requirement, I mean, if you tried to tell the New York Times to be, I haven't met anybody who thinks the New York Times is 100% consistent in its editorial policy. But if you put a state action requirement that they editorialize consistently, or somebody can sue them for $1,000, or the state can haul them into court, I think that would be the most obvious First Amendment violation in the world.
Thank you.
Justice